Well, good. Well, good morning, y'all. I appreciate everyone showing up this time, this early morning, and thank you for that. And we're gonna go ahead and start. And we're gonna start off with Representative Smith is gonna bring us in and with a prayer, and we'll start that way.
17. Thank you, Mr. Chairman. If you would pray with me. Lord, we do thank you for this great day that you've given us again. I ask that you be with each person here, grant us wisdom, be with our spouses that are back home, take care of our children and our grandchildren, lead, guide, and direct us in everything we do. In your name we pray. Amen.
Thank you, Representative Smith. Thanks, sir. We're going to pick up where we left yesterday because we didn't finish. And so at this point, Chairman Petrie. Okay. All right. You're taking all my people. You're taking them as. Chairman Peaster, we just gonna if you wanted to do further comments from the way it was yesterday, the meeting from that.
Yeah, let me explain my changes, Chairman, if I can, and then I might get what I would like is to hear from others. Can y'all hear me? Okay. Let me get my notes here. I will tell you, Mr. Chairman, that my hope was when we left the meeting yesterday. I want to speak to something that was really important. My hope was that we were going to have Zoom access today. We have tried to, with the circumstances we're under, having been through COVID, it's been very frustrating to all of us that we just don't have the bandwidth here in every meeting room to have Zoom access, which is frustrating to me because I've had expert testimony, very interested in speaking, but they're on the coast. And so we thought we were going to have them this morning, and we don't. We also have people that I'm sure from the public that would like to testify, and so we were just discussing that, and that has been a frustration that I think is a necessary part of the process. What I thought I might do is maybe just speak briefly to the changes we made from yesterday to show kind of where we are in the process, that we keep evolving this, trying to get to good public policy, the best version of public policy here as we can. And then, I would like to maybe hear from some folks that weren't able to speak yesterday, particularly DNR and others, because it's helpful to me to get the feedback. I do want to say that I think, as I thought about it last night, and as I heard some of the concerns, I think some of this really could be fixed by the expert testimony, because I think there's some misunderstandings. There's this concern that if in fact the state never responds and they're abjectly negligent, that somehow somebody with a King's Grant written on the back of a business card is going to just somehow have access to a King's Grant. That cannot happen, because remember, even in this process we describe here, which is the process, remember there's two versions. There's you can go to trial or you can take this process. This process is all adjudicated by a special master. And the state at any point in the process, even if they fail with the timeline that we try to present here and the process we try to present, I think some of the concerns are really just like really gross examples of that which would not happen. Remember, all of this is happening in Superior Court with under a special master. And so I think people are forgetting that there's an overarching process here. So there's some confusion, and I will admit this is a confusing bill, and it's an issue that not everybody understands well, and I've made it clear I didn't understand it well as someone who is not an attorney early on myself. But let me do this then, Mr. Chairman, if you don't mind, let me explain the changes from yesterday, because I have multiple iterations. This file is getting thicker by the minute, but we've made it better yet again. And so let me tell you what we've done. so that everybody here, there is a new sub, and I hope we can get this new sub online. Madam Chair Lady, I continue to get people that maybe, yeah. Yeah, okay, that's right. So, but I think that's my frustration is people are looking at the old version, the original version, which was, by the way, from over a year ago. So at any rate, on line 37, if you will look at yesterday's version, same LC number, which is 44202-8S, that was the version from yesterday. I doubt everyone here has a copy of the new LC from last night. Oh, you do have the new one. Okay, I'm sorry. Okay, so the new LC, you'll see on line 37, we replaced all the interest with, quote, the fee simple interest. That was very important to the department. As I mentioned yesterday, the Department of Natural Resources has been helpful throughout the process. The new LC 2028S, Mr. Chairman, is that correct? All right, let me make sure. Nope, that's right. That's 202. Let's make sure. That's the old one. That's the new one. Correct. No, I've got it. Just got to find it. That's the problem when you have too many of these. I'm going to have to start shredding these. Okay. All right, gotcha. I think it's on my desk. All right, so line 37, that's a DNR change. The fee simple interest, so we changed that. Line 68, we changed, this was an issue that I think we had missed that came from Ms. Desrosiers. Line 68 changed low to high. I think DNR also helped us to better understand that. So we changed the word low to the word high on line 68. In this new LC 2059S, and on line in 79 through 84, we made a change. We added a sentence that that Chairman Barr wanted yesterday, basically ensuring that there's a begin date kind of acknowledged by a letter from the State Properties Commission. And you'll see there it says the State Properties Commission shall provide written notice to the claimant of its receipt of the abstract and any other materials. And then it goes on to where we were in the previous version and says, and shall have 180 days, etc. So we've added that sentence. That was from yesterday's meeting from Chairman Barr. And then on line 31, the last change we made yesterday, on line 31, another DNR change, we replace by adding itself of the fee simple interest in the property to the extent provided for in the grant. So that is line 131. And some of these I know DNR didn't, due to the interest of time, didn't have the ability to testify yesterday, but I had, fortunately, the opportunity to meet with them and to understand some of their concerns. This was important, line 131. So, do I need any questions on that? It again changes that all the interest to fee simple interest.
Any questions at this point, member?
So those were the changes, Mr. Chairman, from yesterday. Again, just trying to move this to a better, continue to be a better version. I did get a statement from I've mentioned Mr. Ferris Cadle. He's an individual I would like to have here. Again, I was disappointed to learn we couldn't have Zoom access. That's been a frustration, I know, in many of our committees this year with so much of this being necessary due to the pandemic. Fortunately, I hope this is the last time we have to deal with those kind of limitations. But this is an individual that I do want to mention that I'd like to have present to this, to our discussion this morning. I would like to have him to be able to present and answer questions, and others that are experts because you're talking about someone that, in this case, with Mr. Cadle, has been doing title research for over 30 years and has an expertise, he specializes in Kings and state grants, and he's actually published books on the issue as an expert. And so he has some, he has educated me a great deal on how these things are drawn out and stymied. I don't think at this point I need to, I won't read his comments because it looks like hopefully we'll have an opportunity to have him, be here on a Zoom meeting maybe in the future. And that would be even better. But clearly I think what we know is the process as it currently stands doesn't work in the best interest of our citizens, to those that have an interest in these things. Rather than get into that again, I'm welcome to answer any questions, or we can take this up at another day. But those are the changes, and that's what I most would want everyone to understand, is we continue to try to make this better and better based on input from everyone who's interested. And I will remind everyone again, this bill was introduced a year ago, and it was not until after this session started that I got a single email on it. So, very frustrating.
Yeah. Welcome to our world.
Welcome to our world. Very frustrating. But I digress. Any questions, Mr. Chairman?
Chairman Peacher, we appreciate you going through all that again and the continued work, and we appreciate your work you've done on this bill. And thank you. Thank you,
Mr. Chairman. And again, I hope that we'll have some other testimony that we all can benefit from.
Sure.
Thank you, sir.
Any questions of the committee members at this point? Anybody? Well, if not, then I'd like to move on to where we left off yesterday. We had, I think we had at least 2 people that wanted to speak to this. And Michael O'Reilly, is he here?
Yes, I am.
Okay.
Thank you, Mr. Chairman. Good morning.
Morning.
I appreciate this opportunity to speak with you all this morning. I'm Michael O'Reilly. I'm the Director of Policy for the Nature Conservancy here in Georgia. I'm going to switch to the glasses that I can actually read from that distance at. Okay, there we go. First of all, I want to say that I absolutely have great respect and appreciation for the sponsors who have brought this legislation. I know that they, like many of us in this room, appreciate the value that Georgia's coastal marshlands provide to our state. The natural resources in this unique ecosystem provide us with food, recreation, jobs, economic vitality, natural beauty, and so much more. Since the enactment of the Coastal Marshlands Protection Act in 1970, the state of Georgia's able stewardship of these lands is the reason that our coastal marshlands are exemplary and are the envy of other states along the eastern seaboard. I fear that provisions within HB 748 could threaten the security of this critical natural resource. Ecosystem restoration, coastal or otherwise, is a valuable endeavor, and it's one that the Nature Conservancy has been deeply involved with for more than 70 years. We applaud the bill's intention to support marshland restoration, but we feel that the matter requires further definition and clarity to avoid unintended negative consequences to the state's current coastal marshlands and the people who rely upon them. We're not opposed to private ownership of coastal marshlands, but we must underscore the immense public value provided by this unique and remarkable natural resource. We appreciate very much the legislation's language to seeking to protect marshlands for conservation, but the process by which land title is established should be undertaken with care and great thoroughness. Coastal marshland title should not be automatically granted to private landowners simply due to a lack of timely response from the state. The precedent set by such a significant change could have unforeseen implications well beyond this area of focus. I hear what Chairman Petrie said a moment ago about what is in the bill, but what is in the bill still at line 85 or so has a provision in there that automatically triggers the state accepting the claim that the petitioner has brought. I think that is problematic and is primarily the reason that we have concerns with this. So as currently written, the Nature Conservancy cannot support HB 748, and we believe that the issue requires more careful study. And I urge the committee to not approve the bill at this time, but to provide an opportunity for making it even better. So thank you, Mr. Chairman. Thank you, members of the committee.
Thank you very much for your testimony and coming here. Any questions from the committee? Anybody, from Mr. O'Reilly? Thank you, sir.
Thank you.
Mike Worley.
Thank you, Mr. Chairman, and Madam Chair, thank you very much for the opportunity to speak to you today. I'm Mike Worley. I represent the Georgia Wildlife Federation, which is Georgia's oldest and largest member-supported conservation organization. We've been around for 86 years. We're founded in 1936. I want to thank Chairman Petrie for the opportunity to work together on this, and his partnership and his leadership on this issue. Really appreciate the willingness to discuss and confer. We still have grave concerns over House Bill 748 and its substitute. Now, I'll echo a little bit about what Mr. O'Reilly said, that Georgia's coastal marshlands are a true state and national treasure. I think we all recognize that. And it's a treasure due to the level of protection we, as Georgians, and you as legislators, have provided and placed upon those on those lands. We heard earlier today that this bill was to provide additional services or response to citizens of Georgia that have these claims. But I would like to point out that we're talking here about an issue of public trust. So it's not just the issue of the petitioners. All of us have interest in this. Everyone here, all citizens of Georgia, these properties are held in question, are held in trust for the benefit of all of us Georgians. So it's a point that I think we need to keep in mind. It's for all of us, not just for the ones that are making these petitions. As a matter of fact, I think you might even think about it from the standpoint that would change from the Attorney General's office doing these reviews to the State Properties Commission, which almost acknowledges that the state controls these properties. When the State Properties Commission starts to, would be the one to do that evaluation. I'd also like to point out, we've heard here that the transfer of these grants would allow for conservation of our coastal marshlands and restoration. We do already have a process, and some of these state-owned coastal marshlands, or these properties, I shouldn't say state-owned, these properties held in trust for us, have been and continue to be restored under the state's responsibility. So they're taking care of those marshlands for us and for future generations. So nothing in the current statute prevents the restoration of degraded marshlands. I'm not going to go into the lines. You've heard a fair amount, and Chairman Petrie has done a terrific job of addressing all the concerns that were raised specifically on those. So we did talk about the marshlands in the state being one of the components. I think on line 37 is that the marshlands in the state are currently unmarketable because of any uncertainty as to the owner of every interest therein. I would like to point out there is currently no uncertainty. If a grant is held, the property is held in. If a grant is there and it's provable, then it belongs to that petitioner. If no grant is held, the property is held in trust for the people of Georgia. The new language does change the original proposal for a timeline from 60 to 180 days. One of the things I'd like to point out here, no matter the agency, their duty is to represent the people of Georgia with this public trust doctrine. And their duty is putting those types of time constraints upon those agencies that are required to represent our interests seems a little bit almost manufactured. And I encourage you to think about it from this perspective. These grants oftentimes are 250 years old. They're not published. They're handwritten. They are written in a very archaic language. It requires a fair amount of analysis to verify these petitions. And please also keep in mind that these petitions are presented from the petitioner's perspective. They are submitted to these agencies that hold these properties in trust. So the agencies are required, as part of their trust doctrine, to thoroughly evaluate and vet those claims made by the petitioner. So certainly the research has been done by the petitioner, but it's always done from the perspective of that person that wants to take possession of the land, not from the perspective of people that are responsible for that trust. So these agencies, whoever they are, AG's office or the State Properties Commission, are responsible for that public trust. So the entire premise of this legislation flips the responsibility, flips the responsibility for these properties from the petitioner having to prove to at some point we get to an artificial date or an artificial deadline, and suddenly the state now has a rebuttable presumption that they have to prove that it's in the state's interest. And I think that just that flip is a fundamental change. I think it requires us to really think about this in a much more deep way. And I'd like to quote, many of you know Spud Woodward, former director of the Coastal Resources Division. And Spud's sent an email. Spud is on my board of directors at the Georgia Wildlife Federation. And he sent to me a note that said, the duty of the trustee, which would be the state of Georgia, is to safeguard the property held in trust and to preserve and continuously assure the public's ability to fully use and enjoy the public trust lands, waters, and resources. That's really what we have to keep in mind, and we have to make sure that we get this right. So I do agree that perhaps we need to take some time, really think about this, because it is a fundamental change to one of our true state treasures, one of our true national treasures, and you could make a really strong argument, one of our true international treasures, our coastal marshlands, because of the way we've handled them in the past, are among the best in the world. So thank you for the time to do this. Thank you, Mr. Chairman, for your willingness to work with all of us on this, and I look forward to opportunities to work on it in the future. But thank you for your time. Glad to answer any questions.
Thank you. Appreciate your testimony. Thank you for coming. Any questions? Any of the members got a question? Chair Lady Smith, please.
Thank you for your presentation. And I think, like everybody in the room, we're all trying to figure this out. But in the end, do the laws of the state restrict and protect all these marshlands for the benefit of the public? That's where I'm getting lost. I get the argument in the shift, but even if I could prove my ownership, the King's Grant, I can't do whatever I want to with it. And I think that's where a lot of us are getting confused. So what happens to me now if I had the King's Grant? What can I do with the land that would harm public trust?
Under the specific bill bill that's before us, and it does restrict what can be done on those properties. We also have the Coastal Marshlands Protection Act, but these are sort of it's held by. It's not that it's we're not opening them up to development. It's
Correct.
that we're not
point.
continuing to hold them in the trust for the people. It's a fundamental difference in the way the properties are treated and held.
So, further question? It was my understanding there couldn't be further development because it was always regulated by our laws and our public trust doctrine, no matter who has title. So that's one of the, I'm getting these questions from our committee members and from the public too. So
sure.
How do we understand that? I mean, are we still on a parallel line, or what's happening here? That's the confusion, I think, for all of us.
Yes, ma'am. I understand, that's why I say it's a very confusing issue, and one that I think that we probably ought to look at a little closer and try and figure out all of those answers. I think certainly we protect our marshlands that are held in private lands, in private hands already. Though these are contractual and legal, they're legal protections. But the land currently is held in trust. It's just like saying the state itself may not own it, but the state holds it for each of us, and so they're handling it as best they can for the benefit of everyone. Versus transferring it into private lands ensures that it's held, can't be developed, but it's in the interest of that private landowner. I'm not sure. Perhaps we may have an attorney speaking that can answer that question. But I think where you're getting right to, Madam Chair, is that it is very confusing, and why I think we should walk carefully as we move towards trying to change this fundamental protections that we've had for these marshlands.
Thank you. One more question, Mr. Chair. If I'm a citizen and I have a King's Grant.
Yes, ma'am.
And I know that the measure that I can keep my King's Grant, because somewhere in there I should have to lose it if I don't meet certain conditions. Are those conditions now spelled out to keep my? Do I have obligations to be able to keep my King's Grant? In other words, we might want to toughen up all King's Grants from where you're going with this. As
I understand the King's Grants and the way they're written, there actually were requirements. Oftentimes, my last job before I came to the Wildlife Federation was in community economic development. We worked with companies that came in. Oftentimes, if they didn't meet their obligations, we called them clawbacks, so that people could get back what the estate had invested in them. In this sense, a lot of these grants were granted, and the reason they require so much analysis, they were granted, but they all often had requirements. Perhaps it might be to maintain rice agriculture on the property. Perhaps it might be that the grantees' children had to serve in the military. I mean, there are all kinds of things that were placed upon the requirements of those grants that have to be researched before they are returned back to that private individual and private ownership.
Mr. Chairman, it is my observation that we're now walking through pluff mud. And,
yes, ma'am.
If anybody lives on the coast, you don't want to get stuck in that. So thank you. Thank you for letting me ask all my questions. I'm still clear as pluff mud, but anyway.
Thank you, Madam Chair.
Thank you, Madam Chair. Great questions. Thank you for your testimony. Thank you for coming. I think we see it's complicated.
Thank you for the honor to be here.
Yeah. Okay, I'd like to call April Lipscomb.
Thank you, Mr. Chairman, members of the committee. My name is April Lipscomb. I'm an attorney with the Southern Environmental Law Center. Madam Chair, I cannot at all promise to make this any clearer than Puff Mud for any of y'all. Like the two speakers before me, first, I want to thank Representative Petrie for bringing this bill and for being willing to work with all of us to try to do this right, as he says. And I know I was at least on one Zoom meeting with him, a while back to kind of express some concerns. And I appreciate the changes that have been made. I think those are good changes in the sub that we've heard today. Like the earlier speakers, I too have concerns still about the actual procedure that has been put in place to establish title to marshland through a Crown grant. And the overall takeaway for me is that this process appears to make it much, much easier for someone who either does not have a valid Crown grant or someone who may have gaps in their chain of title. It still provides those types of people with a pathway to obtain ownership over the marsh. It makes it easier for them to do that. And for me personally, I don't think that's right. So in Georgia, I'll kind of quickly pull up something for y'all. Our Georgia Supreme Court has said that in these types of cases where a plaintiff is trying to assert title over land, their right to relief depends on the strength of their own title, not on the weakness of their opponent's evidence. And so what this bill does, though, is flip that around, as Mr. Worley said. And so I'm really concerned about that burden of proof sort of flipping. And I want to highlight one provision in particular that gave me a lot of pause when I read it. It's starting on line 133 through 138, that's subsection B. So this is in, the bill sponsor, Representative Petrie, mentioned that, there's sort of two pathways. You can kind of go first to the State Properties Division, or you can go to the Superior Court. This deals with the proceedings in the Superior Court. And so what that section says is that if there is evidence that the marsh has been altered by man at all, just visible evidence of any marsh alteration, then that means there is a rebuttable presumption that somebody in the chain of title is the person who altered the marsh. They did so believing they had title over the marsh, and they used it publicly, continuously, exclusively, and so forth, and that they acquired title. So all those are legal terms of art. And so what that provision essentially says to me as an attorney is that this provision says that just visible evidence that the marsh has been altered means that someone in the chain of title has adversely possessed that property. So adverse possession is another sort of legal term. And what that essentially means, for those of you who are not lawyers or may not be familiar, is it means that somebody who does not actually legally own property, but they think they do, and they have, they've sort of dominion and possession over the property for a period of time, they become the new owner. So what this essentially says is there is now a rebuttable presumption that somebody who did not legally own the marsh has taken title to the marsh through adverse possession. And that's a rebuttable presumption, only based on the fact that the marsh has been altered. And that's really, really concerning to me, because rebuttable presumptions are a big deal. So what that means in this case is that the state now has to come up with evidence to counter that. So the state would have to come up with evidence that actually somebody else in the chain of title altered the marsh, or that person did not believe they had an ownership right to the marsh, or that the use of the marsh was not uninterrupted or exclusive or continuous or so on. So how is the state supposed to introduce evidence to prove all those things? And a rebuttable presumption, even if the state does introduce counter evidence under Georgia law, that rebuttable presumption remains alive all the way through jury instruction and all the way until the end. And so in this case, we don't have a jury unless there's a fact issue, but there's a special master. So that special master would have to say, okay, well, the marsh has been altered, so I have to accept this rebuttable presumption unless I determine that the state has introduced enough evidence, solid evidence to overcome that presumption. That's not the way that property law is supposed to work. As you just heard me explain, the Supreme Court has said that it is incumbent on the person who was trying to prove title to show the strength of their claim, not rely on the weakness of the other party's argument. And so that gave me a lot of pause, because that means that somebody who may have have an issue with, being able to prove chain of title can still basically assert that they have an ownership right over the marshland. And then the next subsection down from that, starting on line 139, says that, the existence of the grant, which provides a rebuttable presumption that the state has divested any interest in the property, that's in subsection A above, combined with this evidence of a man-made alteration to the marsh, with just a good showing of title for 40 years, creates a prima facie case. So again, that's not the way that property law is supposed to work. And this just gives me a lot of pause because, as I said, this appears to me, at least, to make it much easier for somebody who has gaps in their chain of title or who may not have perfect title to end up claiming ownership of the marsh just because of this rebuttable presumption problem. So I will leave it at there for the time being. I do think that there is a way to get there and to create a process that is fair for people, because I agree that if the state is just sitting on these types of requests, that is a problem, and we need to make sure that people's rights are being reviewed and they're given a final answer, because we can't just leave these things sitting out there. But let's make sure that we get this right and that we're not having unintended consequences of giving away marsh that may have actually reverted to the state already. So thank you for your time and attention. I appreciate the opportunity to speak.
We thank you for coming and your testimony. Thank you for that. Do we have any members that would like to make a comment? Okay, well, thank you.
Mr. Chairman,
Oh, well, I'm sorry.
have a request for how much time is remaining. I, for one, have another meeting I have to be at 9, and who else do we have on our? Are y'all comfortable with?
Yeah.
So I have a question to pose to our subcommittee and to you.
Okay.
Time permitting, this is such an important discussion. Would it be possible for us to attend to the business before the committee, our regular meeting on Thursday morning, and then use the remainder of the time, at which point we'll have Zoom and be able to get some testimony? Would that be something that we can offer to the committee and to the public? Yeah.
So what you're saying is end the meeting here at this level, right? Or okay, just move.
I want people to be able to have talk on Zoom.
So we'll have full and subcommittee on Thursday.
Further clarification, so to those in the audience, because we don't have anybody watching via Zoom or anything, it is confusing enough, and we're here hearing everything, but we know we have people who've not been able to track and follow our committee meeting on Zoom. And if the bill's author would meet with our committee analysts after this meeting and identify some speakers that our full committee can listen to on Zoom to give the general public a little bit more input. This
meeting is on video.
It is on?
It's on video.
Just no testimony. That's my understanding. Yes, the testimony is the concern. We have heard several people who have not been able to use Zoom to testify, so just trying to give enough time. The will of our subcommittee chair. Sorry to do that to you.
Okay, well, I guess DNR has somebody that traveled here. I mean.
Yes, so let's go ahead, yes.
Yeah, okay. So if DNR, you represent, if you come, please. Thank you.
Thank you, Mr. Chairman, Madam Chairman, and Chairman Petrie. My name is Doug Haymans. I'm the Director of the Coastal Resources Division of the Department of Natural Resources. I didn't come with prepared remarks this morning. I came to answer questions where I could help. But I will say this, the Coastal Marshlands Protection Act is beginning its 52nd year this year. And it has done a wonderful job in 52 years of protecting the marshes that we have against alteration and manipulation. There have been instances where there have been illegal activity over the last 52 years, which have been corrected when found. There are some instances where those have not been corrected because we haven't found them yet. We gave to Representative Petrie yesterday a number of about 35,000 acres, or roughly 10% of the coastal marshlands in the state that have been altered in some way or another from hydrology or spoil islands or that sort of thing. I will say that from a department stance, the process, that's up to you guys and how the representative may want to redefine the process. There is a lot of concern over the process, and we absolutely understand that. But from a department, we are interested in making sure that the public interest, the jus publicum, is maintained. And that's why we asked the representative to add the fee simple into the interest to make sure that the state didn't give away the public's interest in this. I'm also very appreciative that the representative the chairman put in there that this in no way supersedes the Coastal Marshlands Protection Act, because it is the Coastal Marshlands Protection Act that permits or denies the ability to dredge, fill, or otherwise alter the marshes of the state. Regardless of ownership, anytime there's mitigation or mitigation work or some alteration of the marshes, it's a federal as well as a state process. Mitigation banks, which I think is at the heart of all of this, is not an automatic process just because you own it. It is still a very lengthy process, and it's not a guaranteed process. I will just mention the fact that the bill contains the word preservation in a couple of instances. The Coastal Marshlands Protection Act already preserves the marsh from those sorts of activities. I think that this simply restates the fact that it's preserved. But I certainly understand the concern that a lot of individuals have over what this may potentially do. I've heard from almost each speaker something that I've thought, and that's the overarching law that we all have to abide by, and that's the law of unintended consequences. So whatever it takes to make sure that everyone's comfortable moving forward, we're supportive of, and we're willing to work with the representative in whatever way we can to perfect the bill. But I'm happy to answer questions regarding the Coastal Marshlands Protection Act, but not so much the process.
Okay, well, we thank you for coming and appreciate your remarks. Are there any questions?
Oh, and by the way, Madam Chair, your stature just went that much higher when you mentioned pluff mud. I think that may be the only time I've ever heard pluff mud in the middle of a committee. So.
I'm going to tell you how old I am, because I knew to avoid pluff mud at an early age. And I was always the one sent out because I was the lightest one and wouldn't go so deep. So, Mr. Chairman, thank you for your time, and to everybody who's making the effort to come up here. And I know we're being viewed, but what we're getting from the bill's author and others is that there are several other people who wish to testify. And the more we dig into this mud, the more it's surrounding us. And so I think that there needs to be a lot of clarity to this. But one question is being raised with me now, and that is the owners of these King's Grant. I just want to be sure they're subject to all the same restrictions and requirements that the public trust requires.
Yes, ma'am. The state garners the public's use of those marshes, right? So anytime that a private owner of the land may want to affect the public's use of the land, right, whether it be waterfowl or fishing or whatever it may be, the state has an interest in that. And so the Coastal Marshlands Protection Act provides that ability for us to interact with the private owner.
Next time you come up, you bring a bucket of pluff mud so we can educate our city folks.
Okay.
Do we have any other questions of the members?
Thank you.
Any comments? Thank you.
you.
Thank you, sir. Chairman Peastry, would you like to have any comments as we close it out?
I think I'm fine.
Okay, all right. We're adjourned.
Thank you.
Tomorrow is canceled, correct?